Good afternoon, Chancery Court, Part 1.
Hi, this is Jason Cohen calling.
Oh, yes, thank you for calling. If you will hold, I will contact Mr. Jake and get him on the line, okay?
Thank you.
Thank you. Mr. Cohen?
Yes,
Okay, continue to hold, please.
no problem.
Mr. Cohen?
Yes.
Okay, we have Mr. Jakes on the line with us now, so
Great.
I'm going to place the call on hold and let the court know that the parties are waiting.
Okay.
The lawyers, this is Chancellor Bonnyman. Lawyers and parties, this is Chancellor Bonnyman. And
Good afternoon.
good afternoon. Do I have Mr. Jakes on the line?
Yes.
Yes, Your Honor.
And how about Mr. Cohen?
Yes.
Okay. So I wanted to, before we start talking about the motions that are set to be heard, my hope is to hear these motions now so that you don't nobody has to come over here on Friday morning and nobody has to worry about this on Friday. Because I have the motion and I have the responses. Either of you have a problem with hearing the motions now?
No, Your Honor.
I do not.
Okay. I want to take up some administrative matters first. One, Mr. Cohen, I need to have from you your physical street address where we can send mail to you. And the local rules require that a filer provide, I've got your email, I've got your telephone number, and I have your physical street address, which I do have to have because the rules of civil procedure require it, as well as the local rules. And you really need to show that on anything that you file.
Sure. So the issue is, and I think I've mentioned this before, is that I do not currently have a physical street address, and so by that statement, like, I mean, the rule is flawed, and I'll give you a reason why. I don't currently own any property. I've never owned any property. 232 Leonard
Okay. That's fine.
was a house that I leased.
I'm not,
Okay.
Mr. Cohen,
Sure.
I'm not trying to find out what you own or what you lease, but you got to be putting your head down at night somewhere.
Yeah.
You got to be voting. My guess is that you're voting somewhere.
Voting? No, I'm not. I mean, I actually don't vote.
Okay. Well, then, do you maybe live with your family and you could receive mail there?
So I do not actually. I'm on pretty bad terms with them. The reason that I actually leased 232 Leonard was my parents were going through a divorce at the time. So yeah, like, I mean, I do live in, like, you know, temporary arrangement, stuff like that, but it's like hostels and hotels or motels. It's not, you know, it's not like a stable, consistent, like, I leased another place. I haven't leased another place since I left Leonard.
Well, where are you staying right now? Like, where were you last night?
I basically, like, I have, like, a girlfriend in a 2003 Suburban. So, I mean, when we're on good terms, like, I say hello to her, and then when we're not on good terms, it's the 2003 Suburban.
Does your girlfriend let you stay with her?
Occasionally, but I mean, I'm actually
Somebody
kind of,
does.
like, on, like, we're not really serious, so it's not like basically, yeah, I
Okay.
mean, full disclosure, I don't have a consistent address, and that's not me trying to be difficult. It's like I don't have one currently.
Okay. Okay. As soon as you get one, I need to have it. I have to have it, and you need to include it on um, any filing that you do.
Okay, absolutely.
Now, just one second. How about what do you do about getting mail?
I really don't get that much mail anymore. Honestly, like most of pretty much everything is online now or through email. So I mean, I really like even if you get like car insurance or even you get like whatever, like you don't really get. I don't necessarily need to get mail. So I don't get mail. Like I don't really get mail.
Okay. Well, let me just say that that's kind of dangerous because, for instance, well, there are government offices that will be contacting you, not related to this case, but just contacting you,
Right.
and you have to update them as to where your address is. But that having been said, I'll move on to something else. Okay. So I want to set out. So this will help us with our discussion about discovery. I want to set out the rules about deposition taking for Part 1, and I do adopt the common law and, of course, the rules of civil procedure that regulate the discovery that both parties can do and do engage in. And the common law and the rules place the burden on the plaintiff to take a deposition of the defendant where the defendant lives. If the defendant lives in Texas, that's another reason why we need an address. If the defendant resides in Texas, and it seems to me that that would be where the defendant is residing now, is in the state of Texas. But the plaintiff has to go where the defendant is unless the deposition is taken by telephone. Then, when the defendant takes deposition of parties, the defendant has to come where the litigation is to take deposition. So, that having been said, now the court's going to take up the sanction question, because that has to do with discovery and the taking of depositions. And I'm very interested to have the opportunity, because I think I have a duty, have the opportunity to look at each of these pieces of paper or documents that the plaintiff is requesting, because some of them the plaintiff is entitled to as a slam dunk, really easy. Some other things maybe not. So I want to take up those individual matters too, because I think that's the best way to manage a pro se, a case where the defendant is pro se. So let's hear, Mr. Jakes, your motion for sanctions, which I believe stems from the defendant's failure to appear at the depositions that you set here in Nashville.
That's primarily the problem. It also includes the problem of not producing the records and the information that we've asked for, which are
Okay. There are really two things. There are really two things that you're complaining about. One is that he didn't come to the deposition, and two, he didn't answer the subpoena.
Right.
Okay.
Back early on, when the case was in its infancy, I sent emails to Mr. Cohen asking him for dates that would be best for him to give a deposition. And early on, he made it clear he had no intention of giving a deposition. One of the emails he sent said, there is, quote, zero chance, end quote, I'm going to give a deposition. And it went back and forth like that.
Mr. Jakes, was there an email where I sent you that I would do it through telephone? I mean, I filed a motion for a telephonic deposition.
Mr. Cohen,
Okay.
Mr. Jakes is going to finish, then it'll be your turn, because there's no other way to do it.
All right.
Okay.
So after I got the zero chance emails, I sent out a notice for April the 13th for the deposition to be taken on May 17th. It had 6 categories of records requested, and none of them were produced. Just the deposition was scheduled to be taken, Mr. Collins was retained to represent the defendant, and he agreed to provide all of the documents by May the 24th if I would put off the deposition, and I agreed to that.
Okay.
Some, but not all, very few documents were produced. And one of the things that we had asked for were recordings that Mr. Cohen claimed he had made of conversations with myself and Mr. Fisher. And Mr. Collins represented to us that Mr. Cohen had told him that those never were made, they didn't exist, and so we didn't get those either. We haven't gotten anything between Mr. Cohen and Airbnb, anything that identifies the people who've stayed there, any insurance that may have been applicable for coverage or liability on the property, nothing that shows where he is living now or has lived in the past. And of course, Mr. Collins withdrew, but before he withdrew, I issued a second notice for the deposition to be taken on August the 10th. And early that week, I sent a number of emails to Mr. Cohen asking him if he intended to appear. And I told him, if you're not going to appear, just tell me, because I don't want to incur the expense of a court reporter if you're not going to show up. And he told me one day he would let me know. Shortly after that, he said, I'll think about it, but I want Mr. Fisher to appear for a deposition after mine. And we agreed to that. Then he conditioned appearance on Mr. Fisher producing tax records, bank statements, property records, and records of political contributions, not just for Mr. Fisher, but for Mr. Fisher's wife, going back a total of 16 years. And this was on about less than 48 hours notice. Mr. Cohen never told me whether he planned to appear or not, so I had a court reporter here, and he just didn't show, didn't call, didn't email, didn't let me know. Since that time, he has not provided any dates. He's given no indication of when he will produce the documents that we've asked for. And in this response that he's filed to the motion, he doesn't offer any excuse or explanation for not appearing or not giving me dates, and he doesn't give any indication of when he does plan to appear. So that's the basis for our motion for sanctions.
Okay. So let me make sure I understand. The items that Mr. Collins said would be provided, the documents would be provided, so the deposition would be reset, are on page 3 of your attachment. That is notice of deposition, and there's
Exhibit 1.
Yes, and there's a page 3 of Exhibit 1 which says items to bring to the deposition. There's 6 of them. Are those the ones that Mr. Collins said he would make available if you
Yes.
would reset?
Yes.
Okay. All right. Okay. Okay. So let's stick with that list first. So, Mr. Cohen, I'm turning to you now, and Mr. Jakes, I'm not wanting to cut you off. I want to come back to you to argue the rest of your motion, but I want to deal with the papers first on these items to bring to deposition.
All right.
Will that work for you?
Yes, but before you get to that, if you turn the next page, there's an email exchange with Mr. Collins and myself that confirms what I just represented to the
Right.
court.
I just read that a few minutes ago, and I'm just thinking that chronologically, kind of keeping things in a chronological position, will be helpful to me to go ahead and address the items that Mr. Collins said he would make available. And I also want to give Mr. Cohen opportunity to say something about what has been said just so far. Not get into anything else, just about what has been said so far. So, Mr. Cohen, what do you tell me just about this early part of the motion where Mr. Jakes has said, I set up the deposition, I never heard from Mr. Cohen?
Okay. I have a few questions of my own. So when you refer to the slam dunk
It's not, Mr. Cohen, questions don't work in this motion context.
What do you mean?
What you need to do is tell me what your position is about
Well,
what
yeah,
Jake
so
said about
I'd like,
this.
I understand. I'd like to respond to specific, so Mr. Jake said a couple specific points. I'd like to respond to each one individually. But before I do, I'd like some clarification as to what he meant exactly and specific dates. So when you were referencing a slam dunk discovery, what specifically do you mean?
No, Mr. Cohen, we're not doing that. We're not doing questions back and forth. That's just not the protocol that works. It doesn't work for me, and it doesn't work for any of the parties, I can tell you.
I was just saying, if we could clarify what I mean, it was y'all's statement. What is a slam dunk discussion, slam dunk discovery, sorry. Like what is that referring to?
Do you have your motion for sanctions in front of you?
Which one? Because there was more than one.
Okay, this one is filed August 11th.
Hold on one second.
Up in the right-hand corner.
It's the most recent one where you're talking about the recordings, right?
Filed, the stamp date says August 11th.
Okay.
I don't know about recent or not recent, but it says August 11th. And you see on the front, he set some dates out if that will help you.
August 11th. I don't recall.
Filing stamp.
I don't recall, but I would just like to say straight up, and I can back this up with, I'm looking at emails now, and what Mr. Jakes is saying is a lie, just straight up. And I'll explain why it's a lie. He emailed me on August 8th. So I outlined in some of my previous motions that his strategy in this case, since his client has no standing, is to try and get me into some sort of inconvenience me into some sort of sanctions. Like that's why he filed for sanctions on the first day, trying to hold me in contempt while I was still traveling. This is his thing. This is what he does, is to try and get sanctions on people for no reason, because they know it's inconvenient. They know it's hard for me to travel with limited resources to travel back and forth, and he knows that. And so when he said also on August 8th, he sent me an email. It's Mr. Cohen, see the attached order from the judge. Please advise whether you plan to appear. He said that I said that there was zero chance that I would appear. The very next email, I said, Jakes, I am available via telephonic deposition. This is my third or fourth time telling you this directly. This is a reasonable accommodation request. You know I'm out-of-state litigant, and you have yet to show any conclusive evidence that your client was in fact injured. That was the very next email I sent to him. So I really don't know where the zero chance is. Maybe that was something said very, very early on when it wasn't even really a case yet, and I didn't really understand why the case was even proceeding. And then, I understood, okay, fine. I will be happy to, but I mean, things change in a case. I said it right there. I am available via telephonic deposition. I have not tried to avoid anything at any point in time, so I'm just making that a point regarding the deposition and the sanctions. As far as the recorded phone calls, I also I responded to his motion for sanctions, and I think it's outlined pretty clear. I casually used the recording app, at the beginning of this year. And there was one call that I ended up getting off of it. It was the rude initial call with Mr. Jakes. And then I had actually lost that phone. And then it was after when I started suspicions, because I remember in our first hearing, I actually went to shake Mr. Fisher's hand thinking oh, maybe he was just some guy, whatever. And there was Jake should get the Academy Award for Best Actor, saying, oh, Mr. Fisher, come with me, don't talk to him, pretending it's just some client that hired him, when it was furthest from the case. That was not it was very non-transparent, very misdirected. And yeah, so as far as the deposition, it's a straight up lie. I told him I would be there, or I would be available via telephonic deposition like we were doing right now. It's very simple. It allows me an opportunity to participate. I'm not trying to get away, but the court should be considerate that it shouldn't put undue burden on people. People work in this country, and not everyone works as a lawyer, and it's very hard to travel at the drop of a hat, especially to Nashville, which is a very, very expensive ticket, for whatever reason. It's a small airport, so I just think that was wrong. So the zero chance email, that's just nonsense. As far as Mr. Collins, addressing him specifically, he was, for lack of a better word, and I don't mean to be, use this to offend anyone, but he was garbage. He was, whatever he and Jakes did, I had no clue of. He didn't listen to me, and I have proof of that as well. He didn't listen to any of my wishes. He kind of did what he wanted. He was very late in filing motions. He just seemed like he seemed inebriated on many of our calls. That was just, I'm telling you that, I'm disclosing that in private. But yeah, I mean, he was horrible. And the only reason I didn't fire him is eventually, I may need to do, first off a DTPA with him because he misrepresented, his abilities, and also just he was just a horrible representative. That's why I took over the case myself. Furthermore, when we were talking about all this discovery, when Jakes was referring to my discovery requests, they were entirely reciprocal. I mentioned the abuse of discovery. That's why I filed a motion for protective orders. I filed that because of there are certain things that should be allowed to be requested in a deposition, and there's certain things that shouldn't be. All of the discovery should circle back to if in fact it was part of how Mr. Fisher was actually damaged. And to this point, there has been no...
Now, Mr. Cohen,
yeah.
Mr. Cohen, just let me
There was
stop
no
you just
evidence
for a
showing
minute.
how he was damaged, period. There was no receipts, there was nothing.
Okay.
Go ahead.
Can you hear me?
Yes, I can hear you.
Can you hear me?
Yeah.
Okay. So I'm limiting discussion right now to the deposition that is discussed on page 1 and 2 of the, on page 1 and 2 of the motion for sanctions that was filed August 11. I'm really focusing on a narrow question here. I have two things I'm focusing on. One is, what happened, in your opinion, about the depositions that were scheduled for May 17? Your lawyer gets a resetting, according to Mr. Jakes. Your lawyer gets a resetting because he promised to provide the 6 items that you were to bring to the deposition. So,
What were those 6 items? And I'll respond to them individually.
Let me listen to my question.
Sure.
What is your position about the deposition that was to be taken, was scheduled on May 17th?
Give me 1 second.
May 17th of this year.
What is my position?
Yes.
It's not a singular question, it's a multi-part response. But my first response would be Mr. Jakes and Mr. Fisher never had standing to bring suit in the first place. So that's really already been taken care of because we've got a lawsuit. Well, yeah, and that to be honest is suspect as well. So yeah, I mean, as far as May, I'm trying to find this May 17th deposition.
Well, how about the August deposition, August 10 deposition? Did you
Yeah,
know about that?
August I responded to. I said I'm available via telephonic deposition. I have emails from Grover. I told him, yeah, I am available via telephonic deposition. I am making it more convenient to him.
But
at no point in time, I said, and even on my motion, on various motions, I said he is welcome to come to Texas and take my deposition anytime he wants. The issue is this: is that with the attorney and with the lawsuit and at the time, it's a lot of money involved on my end that I've had to spend. And if there's any way to sort of very conveniently, backstop that, then that's what should be done. And so I've mentioned many times, and I can provide the court many instances where I tried to.
You finished. You answered my question. Now I'm moving to this list, numbers 1 through 6. I'm moving to that because these were the documents that your lawyer said he would provide. So I want to go over each of those and see which ones you've already provided, so I can determine which ones are still to be provided. Do you have that list in front of you, or do I need to read it to you?
If you don't mind, if you could read it to me, that'd be great.
First one, any and all communications between the defendant, Mr. Cohen, and any person, firm, or entity regarding rental, of the property at 232 Leonard Avenue. This request includes entities including, but not limited to, Airbnb. That means
Was
all the
anything
papers that you have.
given to? Just out of curiosity, what was Mr. Fisher's damages again? Like, how was, regardless of Airbnb or no
Well-
Airbnb, how was he damaged?
So, Mr. Jake, as to number one, what did you get as number one?
Like I said, I don't have any. Grover was, he came in and went, and
I'm
he
asking-
really acted
that's
independent of
fair.
anything that I wished. Like, he did what he wanted to do to cover his own butt because he missed deadlines. So I don't really know what Grover
Mr.
sent
Jakes, are
him.
you there? Mr. Jakes?
Yes,
Okay, you're there?
yes.
Okay. So, number one, did you get any materials from Mr. Collins or Mr. Cohen in response to this item number one? Communications between the defendant and any person, firm, or entity?
No, what I did get.
That's
was
not true.
not
I can look it up,
response
actually.
to
Hold
number-
on.
Wait.
Let me look it up.
Wait,
Give me a
Mr.
second.
Cohen, I want to know what he says, then I'll find out what you say.
Okay, cool.
All right, Mr. J?
What I got from Mr. Collins was some sort of, it looked like some sort of bank records that showed there had been some deposits to Mr. Cohen's account, which were based on rental of the property. And I couldn't tell much other than a figure, and that's what I got from Mr. Collins.
That's it.
Yes.
Are you sure?
And that would really be in to item number two. Okay.
Yes.
Okay. So,
So is there any recourse if he's
and
mistaken?
what-
Like, if I can pull up an email right now showing what Grover sent him? I mean, that's just a lie. There was other stuff sent to him.
Your Honor, I could be mistaken, but I'm certainly not.
Well,
lying.
I suggest you
If I
double
missed
check before
something-
you make statements.
now just a minute, Mr. Cohen. Don't interrupt Mr. Jakes.
Okay.
If you do that, I just have to end the hearing. Okay, Mr. Jakes, go ahead.
If he sent me something, or if Mr. Cohen claims he sent me something, it
Uh-huh.
could have happened. But I've spent quite a bit of time preparing for this hearing and preparing this motion. So if there's something that's been provided to me that I didn't receive or that I've overlooked, I'm happy to hear about it.
Okay. So let's see if we can make this a little more streamlined. Mr. Jakes, you believe that the only document you were provided was a copy of a bank statement or some sort of bank record showing one deposit or two deposits or what?
Well, it was like a 2 or 3 page document that showed deposits made to Mr. Cohen's account on various dates.
Okay. And do you happen to know what period, for what period of time, like was it from January 1, 2017 to June 6, 2017, or what was it?
I don't have it right in front of me, but
Okay.
it was between the time that the property was rented and the date that the documents were provided. It was around that
Okay.
period of time.
So it was during the time it was rented and we think Mr. Cohen was using the property.
Yes.
Okay. So.
Okay, so you have no other discovery.
now-
You're saying right at this
Okay.
time you have no other discovery.
He's saying
I
he
have-
did not get any other papers from Mr. Collins.
Okay.
So now, Mr. Jake, why don't you tell us what you think Mr. Collins gave him? And why?
As I recall, he gave me some supplemental responses to requests to admit. He gave me those bank records that were I've just described, Your Honor. He didn't
That's
give
right.
me any communications because he said there were none. He didn't give me anything showing current or past residences. He didn't give me any insurance documents.
Wait, can I ask you a question? How do
Provide
past
me-
residences affect how Mr. Fisher was damaged?
Well, that's not what the document production is about.
How is
So,
it should be the document production should be 100% related to the case. If Mr. Fisher was
But
damaged,
I'm
this
the
document.
I'm the one who decides whether it's related or not. Unfortunately, you don't get to decide that.
Fine. Is this Ms. Bonnyman?
So, all of these documents that are mentioned in items to bring to the deposition,
Uh-huh.
those are all reasonable requests. There's nothing wrong with any of them. they may lead to information that's going to help the plaintiff with his case.
Okay, so let me ask you a question.
So,
hold on one
that's
second.
why-
Is this
wait.
Okay.
That's why I'm wanting to know what you believe was provided, and let's get this part done.
Okay. Is this Chancellor Bonnyman?
Yes, it is.
Okay, cool. Sorry, I've got confused if it was still the administrative lady. Okay. So I feel that much of Jakes and Fisher's requests. Let's go line by line. What were the 6 requests, and see how they circle back to if, in fact,
Well,
Douglas Fisher was
we're
damaged.
not worried about how they circle back.
But it's
Mr.
important.
Cohen, I'm not worried about how they circle back.
It's
these
important.
Things. I just want to know, did you provide these things? That's all I care about right now.
Absolutely, and
Number one,
I provided
any-
some of the things, but honestly, like when you think about it, I like even the financials that he has right there, I objected to. I objected, and I can show you emails with Grover. I was like, he doesn't need my bank account. You know, when someone is injured, you show receipts, you show damages, you show credit cards, you show something that says like, oh, he ripped me off in some way. None of that has been
But Mr.
provided
Cohen,
up until this point.
Mr. Cohen, you're philosophically telling me what you think should happen, and that today that doesn't matter. So I'm asking if you know whether any of these things have already been provided.
What are the line items?
Number one, so you don't have in front of you. You don't have the motion for sanctions in front of you.
I do not.
Okay. Do you have it accessible to you somewhere near you?
Okay, let me see. Hold on. Motion for sanctions. Give me a second.
And it's stamp filed up at the top. Should be stamp filed August 11. And if you don't have a stamp filed copy, and you might not, I just realized, then go to the back part of the motion. It says this motion is expected to be heard on August 25th.
Give me 1 second.
Yes. It's got one exhibit attached to it. It's got about 6 exhibits attached to it.
All right. Motion for sanctions. It was August 11th.
It was stamp filed August 11th, but you may not have a stamp filed copy.
Well, that's not
So
good.
I'm
Hold on
trying
a
to
second.
identify it for you so that you can find it.
Give me a second.
It has 5 exhibits attached to it, and the first notice of hearing was August 25, 2017, and you'll find that on page 3 of the motion, where Mr. Jakes signs the motion and takes responsibility for it.
I do not have it. Can someone email it to me?
Well, let's just move on because I need to hear. I'm hearing the motion now.
Right.
the
Yeah.
first
I mean, so
item-
as far as the sanctions, like, you know, it's pretty common law that, you know, there are limitations on discovery, and it should be pertinent to the case. That's all I'm saying. And I mean no disrespect. I mean no like whatever. But what is the questions are what is the case, and if the discoveries. So the second discovery request from Jakes included tax returns from like 2004.
I'm going to get to that.
Okay, yeah,
I'm
those.
going to get to that.
I mean, yeah, go ahead.
Don't worry about that. I'm going to get to it. Some things he's absolutely entitled to. Some other things he might not be. But right now I'm talking about 1 through 6 because I've already ruled that he's entitled to those 6 things. So
My question is this:
sounds like-
what were those 6 things? It's very quickly. Just tell me what those 6 things were.
Communications between the defendant and any person regarding rental of the property. Documents reflecting payments that you received from any source related in any manner to the rental of the property. That is, he's looking for the income you got from the property.
Understood.
3.
So what I'm trying to say is that discovery request was requested prior to his 3rd amended complaint, which seeked unjust enrichment.
Mr.
So the
Cohen,
timing is off.
I'm reading you what these requirements are. I'm
Okay.
not talking to you about them. I'm just reading them to you.
Okay.
Number 3, documents reflecting the identities of any and all persons who have rented the property in question, which is the property on Leonard Avenue, since November 2016. So, you know.
So with
You have these papers,
specificity, so those identities of those people, those private persons, how does that relate to if Douglas Fisher was damaged in any way?
You know what? This is something I want to know. So let's just move on. Number 4.
But it was a very
insurance
simple question. They don't. It has no bearing whatsoever on if, you know, I mean, these are important things to consider. I mean, they're essential things to consider.
Mr. Cohen, do you have any insurance agreements that show that the property on Leonard Avenue was insured? Do you have anything that would show us that that property was insured?
There was $1 million insurance policy. If in fact there was an Airbnb taking place, Airbnb provides a $1 million liability insurance policy for anyone that rents under its umbrella.
Okay, so Mr. Jakes is entitled to see that insurance policy.
I know he has it because I know Grover sent it to him. I can actually show you that. Hold on one second. I'll tell you when the email was sent.
Well, then that means that you have it too. If he has it, if Mr. Collins had it, then you've got it also. Is that right?
Okay. What is your point? He got it. He received it.
No, I'm saying, do you have it?
With
Do
me?
you have such a thing? Sounds like you do.
I think it's located on the
Is that right?
Airbnb website. Anyone can look it up.
All right. The other one is any and all communications with the plaintiff or other representative of the plaintiff, including emails and recordings. Do you have any recordings of Mr. Jakes or Mr. Fisher?
The one I had of Mr. Jakes, I've already submitted as evidence.
Okay, you submitted that as evidence.
And it was found after the
And you've already
fact.
filed that. Is there anything else that you have not submitted as evidence?
Possibly. I think the next step, I mean, because this case has sort of morphed a little bit from a lack of proper disclosure. And I mean, it's very easy to circle back to like civil procedure and all those different things, which Douglas Fisher actually had a hand in creating. But I think what the important thing is to realize is what's right and what's wrong. So as the case evolved, I found out some things that were very wrong that may be somehow misconstrued as legal. But just all of this nonsense, we had a contract. It was a lease. It was very, very clear. There was no limitation of use of any kind. This entire case should not exist.
Mr. Cohen, I'm going to put you on hold just a minute because I'm thinking about a remedy here. Hang on just a minute.
Okay.
I'll be right back with you. If we drop the call, we'll get back in touch with you.
Okay.
Mr. Cohen, do I still have you on the line?
Yes, ma'am.
Okay. Now, one thing that I want to do as we move forward on this motion for sanction, and also implicit in the motion for sanction is I don't have these documents yet. I'm entitled to them. And I see, Mr. Cohen, that you have a motion for a protective order as to the second set of documents.
Right.
Well, I guess you've got it down as to all of them, 1 through 6 and then 7 through 10.
Right.
I believe your lawyer waived any problems that there might be through 1 through 6, but I'm going to allow you to argue your motion for protective order regarding these items.
Okay.
Because I want to be sure that I hear everything you have to say.
Chancellor,
Uh-huh.
this is Bill Jakes.
Yes.
Let me let me correct something I said earlier that
Okay.
Mr. Cohen was correct about.
Okay.
On June the 13th, Mr. Collins sent me 2 documents that are found on the Airbnb website that pertain to an insurance program that they offer. They're just something that was printed off the website. They don't show that they were ever taken out by Mr. Cohen or anyone else on the policy. It's just something printed off the website. And then there, on that same date, I was provided some sort of communication, like an email, between someone named Robert and someone named Mark with Airbnb about the service being deactivated on the date of April the 7th. So he was correct and I was not.
Okay. So,
so the point I would just like to make in response to that, if I may, and this is just for clarification, this case has been predicated on the use of Airbnb to rent a house. If in fact Airbnb was used to rent a house, by default, that insurance policy would apply.
and I don't know whether this insurance policy would be something you would have to pay for. I have no idea. But all I'm interested in right now is what documents were provided in compliance with items 1 through 6. And it looks like some of these documents, for instance, any and all insurance agreements reflecting any coverage for the property in question. It appears that that's the only paper that Mr. Cohen has that has to do with any possible insurance on the property. Would that be right, Mr. Cohen?
So what I would like to say in regards to that
this Airbnb document is the only one?
Well, I would assume so. And the reason I would assume so is on that, so if Airbnb was used to rent that house, there is $1 million insurance policy right there. That circles back to my question. What was Douglas Fisher's damages? If it was less than $1 million, we don't have a case. If it was $0, we really don't have a case.
So the only insurance agreements that you argue might cover the property is an Airbnb policy.
So here's the thing also. The complaint has been... Let me finish. The complaint has been amended a number of times. So originally, there was an issue with I may have invalidated his insurance, right? Which was ludicrous. Didn't happen. He leased it to another person 2 weeks later. Then he amended the complaint for unjust enrichment. The reason the timing of all this is off and the reason I have a very strong abusive process claim is he requested my bank statements, which would be in line with an abusive process claim, before the abusive process claim was in the third amended complaint or in his final amended complaint. So we're talking about two different things. One thing, he was claiming the insurance, which since nothing was ever reported to the city of Nashville, I have a recorded call for that. Nothing was ever reported. If there was something that would have happened, there was an insurance policy, but nothing did happen. No one was injured. There was no fire. There was no police report. There was nothing. That would have been the first case. The bank statement, so that's why I'm objecting to these individually as I've invalidated each one of them. The insurance claim, okay, so you have your piece of paper, but what was Douglas Fisher's damages? 0. As far as unjust enrichment, what were his expenses as a result of whatever my activities in the house were? Also, circling back, did our lease have any limitation of use or scope? No. These are important things to realize. And that's why it's an abusive process, because he kind of had an idea of what he wanted to do, but he wasn't consistent in executing it.
Okay. So what I'm trying to figure out at this moment is what papers, documents have already been provided under 1 through 6, any and all communications, any and all documents, any and all documents reflecting identities of persons. Have you provided anything through Mr. Collins or otherwise Mr. Cohen about the identities of persons who have rented the property in question?
Identities of renting the property in question. Circling back, how are the identities of anyone who may or may not have rented the property related to if Douglas Fisher was damaged? Like, how much was it? Was it an amount per person? Was it Like, was there a specific person who did some damage to his property? How does that relate to if he was damaged? The reason I filed a motion for protective orders on the second one is it included the first one. They're not relevant. It doesn't make a difference who was in there. Black, white, blue, Asian, Chinese, doesn't matter who was there. How did it ultimately affect if, in fact, Douglas Fisher was damaged?
Okay, so you didn't supply any documents, and you're seeking a protective order on that one.
Absolutely.
Is that true?
Yeah, he's asking for stuff like my tax returns from 10 years ago. Come on. Like, or where I used to live. It has no bearing whatsoever.
We're not, Mr. Cohen, we're not there yet.
Okay.
Okay. The only insurance agreement you have is something that was taken off the screen at Airbnb. That's all that's there, and nothing else. And you have not. You're seeking a protective order about your current residence and past residences.
I'm seeking a protective order over it exhaustively, like all of it. It's not relevant. Douglas Fisher has no standing to bring case. He has not provided any documentation as to if he was damaged or not.
Okay. Anything else you want to say about a protective order?
Yeah, I would like for the people involved to be considerate. You know, it's very easy to try and fall back on, oh, I'm a lawyer, I'm a judge, this is the law of the land, and like that's great and everything, but before all that happened, there was right and wrong. And I think it's wrong for someone who really wasn't damaged at all, who owns a house outright, who had at least 2 weeks later, there was no property damage, for him to put me through having to hire a lawyer, 7 months of headache and uncertainty, all of the many motions and emails and all that time that should have been spent working. Yeah, all of his discovery is nonsense. There's nothing to discover. There's no damage. There's no damage. This is a witch hunt for no witches. There's nothing there. And until he can prove with a receipt from even Wally, the garbage collector, I had cameras in the house, and I still have the photographs somewhere. I don't know where the DVR is, but there was no garbage. There was no garbage. I mean, do I need to prove that he was a liar again? There was no. I mean, maybe the trash can was a little full, but it wasn't in some way that was like a hazard, like where it was scattered all over the front yard. There was nothing like that. So, I mean, you know, Jakes came out the gate exaggerating and lying, and that's wrong. Like calling me malicious and stuff like that. I seeked a house because my parents were involved in a divorce, and my apartment, my 1-bedroom apartment, was getting too full with relatives. Okay, I seeked a house with very good intentions. It was my home. I think Mayor Barry, your mayor in Nashville, and this is why maybe she should be like, you know, she should understand how this very, very new statute can be misapplied and misused. I mean, she said on the front page of the website, Airbnb is a great opportunity for people to make a little extra money when they're traveling or when they're out of town. And I think I mentioned in the first hearing that I was in China at the time. I think that meets the criteria of out of town. I mean, there should be no case. There should be no more discovery. There should be no depositions. Like, if anything, I have a very, very strong counterclaim at this point.
Okay, so now we're starting to, I think you said what you have to say about the protective order. Now, Mr. Jakes, do you have in front of you Exhibit 3, the items to bring to the deposition?
I do.
Okay. If you could go through, and Mr. Cohen, I don't want you to interrupt. This is Mr. Jakes' time to talk now.
Okay.
Mr. Jakes, if you could just go through each of those 10 items, and I'll give you a heads up, I don't think you're entitled to all of them, but I want to understand how it is that for each of these items, the plaintiff is seeking documents relevant to the subject matter involved in the pending action, whether it relates to the claim or defense of the party seeking discovery, and is the information that you're seeking reasonably calculated to lead to the discovery of admissible evidence. And that's what we're talking about here. So, could you go through, if you would go through each of them, and I'm looking here for something that's concise, and, but, you know, you get to say whatever you want to say.
Okay. Okay, beginning with number one, I think that communications between Mr. Cohen and any other person or entity regarding the rental of the property is directly relevant to the claims that we've made. I didn't hear any argument, and I don't think there can be any about how that is not relevant.
All right.
But what sort of agreements and communications he had about when he entered into these agreements with Airbnb, when he terminated them, if in fact he was the one who did it, we'd be entitled to discover those. So I think that those are directly relevant. And the amount of money that he received from any source relating to the rental of the property in question goes directly to the claims that we've made. I think that they're relevant. Documents identifying the people who may have rented the property in question are relevant. I would like to be able to confirm to them some of the things that Mr. Cohen keeps representing to the court, as well as how much they actually paid and the condition of the property while he was in China or wherever it was he was when he wasn't there. If he took out any sort of insurance agreement on the property that would protect Mr. Fisher, we need to know that because of the risk he put Mr. Fisher at by his actions. I've looked at this Airbnb website publication, and I don't think it covers Mr. Fisher, and I don't think it covers personal liability. In fact, from what my reading of it, it says it does not cover personal liability. So I think that's relevant to what we're claiming. Any communications that Mr. Cohen had with Mr. Fisher or myself, I think are relevant. I want to be able to rebut what he says or what he represents to the court when he calls me all these names and when he calls Mr. Fisher all these names. And any communications that he made presumably are related to this case and would, for that reason, therefore, be relevant. I want to know his current and past residence, much for the same reasons Your Honor does, because I want to be able to serve him through the mail like the rules require. I want to know his ownership of property in the past so that I can determine the credibility of his testimony concerning his idea and knowledge of what he was doing when he rented this property that belonged to Mr. Fisher. I want the tax returns to show what he received for rental income on this property. For one thing, I also wanted to show what he has done in the past to go to his qualifications for testimony, his credibility, and to determine whether or not he's as innocent as he claims he is as far as business dealings. There is a claim for punitive damages, I believe, and his net worth is directly relevant under Hodges versus Tooth. So that's another reason we want that. Same for the financial information sought in 9 and 10 would be the same as the reasons I've just related to Your Honor for the other information.
Okay. So, lawyers, my best judgment at this time is that I will, having heard from both sides, I'll issue an order, and the order will have some explanation in it.
Can I say one more thing, please, which I think is very important?
All right.
My past residences have zero indication. This was not a business dealing. I leased a house from him. It was only business towards Mr. Fisher. It's like saying to someone, hi, I'm going to lease you my property to explore minerals, right? And oh, you're producing more minerals than I expected. I want more money after the fact. This was my home. Okay? Like this was my house. And yes, like I guess there's a little bit of crossover with the allegations of an Airbnb, but all this stuff about like I want to be able to serve him. You can serve me just fine on email. My net worth is none of your freaking business, man. We didn't have, with all due respect, I leased a house from a landlord to live in, and this was not a business. This shouldn't even be in chancery. This isn't commercial litigation. This is a young man who lived in a house, and when he was out of town, he was alleged to have subleased it to someone. When you talk about the insurance claim is only relevant to if he had any damages. You don't need to see putting someone at risk. Okay, but how was he damaged? Where was the damages? There are zero, and all of these things are very, very relevant. There were no damages. The insurance, those are two different things. We have insurance and unjust enrichment. Unjust enrichment is very flawed because he had no additional expenses as a result of my tenancy at his property, 0 additional expenses, and the insurance is invalidated because he had no damage. You have no grounds. Well, all I'm trying to say, Your Honor, is Mr. Jakes has no grounds to request these things, period. And they are abusive discovery.
Okay. Heard both sides now, and that takes care, for the moment, of the motion for sanctions. And the other motion is to strike the counterclaim. And I'm going to take that under advisement as well, because, and reserve a ruling on it, because I want to see what's going to go forward in this lawsuit to see whether a counterclaim can go forward under the circumstances of the case.
I think it should. I think it's very obvious, like, especially since he was asking for, plaintiff asked for in discovery, like, my bank statements prior to the unjust enrichment amended complaint. And he also made an email of it at the beginning of, like, the case, but still managed, and this is someone who's a very tenured lawyer, for him to say, I made all these, come on guys, like, this is very, very cut and dry. This is an abusive process. This is not what the courts were set up to do, and especially Chancery. Chancery is for businesses, this is not a business. This is really, really wrong what took place here.
Okay, so Mr. Jakes, let me correct what I said. I'm not going to take the motion to strike the counterclaim under advisement. What I'd like to do is just reserve a hearing until I see how things are going to go on these documents. And I think that will save a lot of time.
Okay.
So, yes.
And
two things.
Okay.
If there are, go ahead, Mr. Cohen.
All I wanted to say is this: I'm here participating. There's no need for sanctions. Like, I will. And this is something that's very important to realize. Like, I am participating in good faith. I believe in a solid judiciary and a solid legal system. That's what makes us not Venezuela or Nigeria or another third world country that's really corrupt and messed up. So I'm participating. I'm here on my phone all the time, and I would like to participate in the motions. I would like to argue my claim, and it's, as you can see, it's not that difficult to get me on the phone. So I would like to continue doing that in the future, which was another motion that I requested.
Well, I'll have to decide on a case-by-case basis.
I just think that it's very, it puts me in a bad position to have to, it really complicates my life in a way that's unfair for the expectation to be that Jason can just fly in for every single motion. You see how many there were up there, I just checked it the other day. There was a ton. That would have been literally thousands and thousands and thousands and thousands and thousands and thousands of dollars on top of the thousands of dollars already spent just to have a couple exchanges of words. I just think it's not efficient. It's not right. And I think if this is a just court, we should continue allowing me to participate via phone.
Okay, so I think we've covered all the sanction issues and motion for sanction issues. And as I said, I'm just asking that the counterclaim, motion to strike the counterclaim, be reserved for a later date as things become more clear to me.
Okay, so, if you want to do your research, but I think...
Wait a minute.
Yeah, sorry.
I'm saying this to Mr. Jakes. So, Mr. Jakes, I'm saying I think it would be more efficient to deal with the sanctions motion first, because sometimes the result of that determines just about everything else.
Okay.
So I'll see how it goes.
There are a couple of things. To the extent that Mr. Cohen has objections concerning his privacy, we're of course agreeable to some sort of order that protects that. Second, if Your Honor orders Mr. Cohen to give a deposition, I'd like, a time parameter for him to do that. I don't expect you to set a date certain, but say within a month or within 2 weeks or whatever. I would appreciate that from the court. Third, I'm sorry.
I will, as a part of this motion for sanctions, I will put down some time during which the deposition can be taken, and need to go to Texas if you take it in person, but you can take it by telephone if you want to.
All right, I understand. And,
So,
I'm sorry.
I'll set out a certain period of time within which you can do that.
Okay,
That's reasonable for everybody.
all right. And
But you
last
need,
thing,
you need your documents first.
correct. And the last thing I wanted to provide the court is the zero chance I will make an appearance in your office for a deposition email that Mr. Cohen claimed he never sent. And I'm copying the court and Mr. Cohen on it right now.
Well,
So just to circle back to that, I said I may have sent it early on when I didn't really understand the nature of the case. I've never been sued before, and you were being very disrespectful and very rude, and that's why I said it then. But after that, I said multiple times I'm available via telephonic deposition. So let's be very clear about that.
So would I be right to say, Mr. Cohen, that you retract that?
1,000%.
You're retracting that.
1,000%. And the only reason I said that at the beginning is because I knew, with all due respect, and I'm not, Mr. Jakes is probably a great lawyer, and it's as he should be for his client. But the reality is that's why he wanted to, because he knew it'd be unnecessarily burdensome for me to have to fly in. It's at least $1,000. Flights from Texas to Nashville for whatever reason at the last minute are $800 plus a rental car plus a hotel room for the evening. That's $1,000. That's $1,000 move every single time, and that's just not fair. It's simply not fair, and he knew that at the beginning, and that's why I said that originally.
At the time, Mr. Cohen was living at the property over on the West End area.
Well, and I also have to say, Mr. Cohen, we're not sure where you're working or living now, and that makes it difficult for anybody to know what to do.
I understand that, and all I'm going to say about that is you guys are privileged in the sense that you guys both have very good professional jobs. You guys obviously, I'm sure, live in decent houses, stuff like that. That is not the majority. That is not everyone's situation. Not everyone has the exact same situation. And when they say oh, you should just go stay with your parents. When I say that me and my parents have a horrific relationship, it's not that because I want that to be the case. It just is what it is. And some people have different situations. So to just assume that I automatically have a stable address and just because I write well just means that I'm completely settled in my life is just you guys are assuming a lot, and it's just very inaccurate.
Okay. I do understand. I think, Mr. Cohen, everything you said. I'm thinking I also understand Mr. Jake's position. So I'm now going to hang up, having taken up the motion for sanctions and having delayed the motion to strike the counterclaim. And in the order, I will address a period of time to take a deposition, whether it's by telephone or in person. But,
Thank you.
Mr. Cohen, are you now working out of Texas, or are you working out of Tennessee, or what are you working out of?
So the reality is I'm out of the country right now. I'm not even in the U.S. anymore. And,
Are you going to stay here? What's your plan?
I don't know. The U.S. is really messed up. People are getting shot up there every day. The government can't seem to get its stuff straight. The job market is anemic. I don't know. What do you want me to say? It's very easy to leave the U.S.
Well,
there's cheaper places to live. There's more comfortable places to live. And there's what I would assume is fairer places to live.
Well, the reason I need to know this is I need to know what to do about your deposition.
I think Mr. Fisher is.
To know where he could.
Sure. So Mr. Fisher is 90 years old. Okay, I had a 90-year-old grandfather once too. I don't think he enjoys traveling, and I think it would probably be very exhausting for him. Pardon?
All his lawyers would be traveling for him. He wouldn't. I don't know if he's come or not, but that's
okay.
Irrelevant.
I think a very reasonable accommodation for both of us, since the value of this case is so low, and at least in terms of where the plaintiff is coming from. He's seeking what, $5,000 or less in damages, or lawyer's fee or whatever. Since the amount is so low, I think we should all because that's important to realize. When plaintiff's suing for $5,000 and I'm already $5,000 out of pocket, it just seems wow, that's ridiculous. Why don't we both just agree to take a telephonic deposition? The facts of this case are not. This is not a complicated case at all. So I just think, and that's a suggestion. It's not like, that's just something that I'm suggesting to, the other side. Like, let's just both take a telephonic deposition.
Okay, now, Mr. Cohen, where the plaintiff has the right to take your deposition,
Right.
I think the best place to take it is probably in Texas.
I'm actually
Unless you now have
fine. I'm not in Texas right now, but maybe I could. I have to head back maybe in like a month to renew my passport.
So where will you be in Texas?
I don't know yet. Like I said, I'm on very bad terms with my parents who live in Houston, so I may be in Austin. I don't know. Like, I really don't have an established place.
But we need a place where your deposition can be taken.
I understand. Well, first ask. I mean, is a telephonic deposition okay? Like a reciprocal telephonic deposition?
If Mr. Jakes is willing to come where you are, he has the right to take your deposition in person. If he's willing to do that.
Currently, I'm in South America, so if he wants to come here, he's more than welcome to.
What about this law firm where you fax things from? What about that as a place for your deposition?
They don't represent me. It's actually just a friend of mine who let me use her fax machine.
But would he also he or she would let you use the conference room for a couple hours?
Probably not. And only because I'm not a client of theirs. Like, I literally is just like a friend of mine who let me use her fax machine because I don't have a fax machine.
Well, you have to tell me, what city is that in?
That city's in Houston.
In Houston, okay. So you tell me, it seems to me that... I
want a request for like a regular deposition. I don't understand why a telephonic deposition is so difficult. I don't understand why, we need to be breathing the same air.
But you don't get to make that call. That's not a call you get to make.
Okay, so, but I'm just saying, circling back, like, Jakes has no standing. Fisher has no standing. There should not be a case. I should not be convenienced as an individual to have to, like, I mean, Your Honor, there's been so much documentation. Just read it. Like, all these things about, like, procedure and all that stuff, it's just excuses. It's just like, here, let's misapply the law. I don't want to see Bill Jakes. Honestly, I really don't. I am available.
You're not giving me a place where your deposition could be taken in Houston.
Currently, I'm out of the country. And the reason for that is I understand, like, people don't.
That's all I wanted to know.
Yeah, I'm out of the country.
Okay.
Here's the thing. It's much, and the reason for it is cost. It's much cheaper to live other places than the U.S. It just is. There are certain places where the standard of living is decent, but it's much cheaper. And that's something that should be respected. Like, just because I'm a U.S. citizen doesn't mean I'm trapped in the U.S. For life. It doesn't work like that.
Okay, I think that's all I had today. So,
but I mean, honestly, Judge, like, without like any sort of, let me just finish, please. Let me finish, please. Without any sort of misdirection, like, if I will get sanctions for not appearing in Texas, I think that would be wrong. If that is like your intention, then I will find a way to try and, like, either come back to Texas or, like, we'll figure something out. But I think a telephonic deposition is fair for everyone. And based on the value of the case, it's just not fair for everyone to have to keep uprooting their lives. Like, at this point, I really think, like, it's like, oh, egg on face moment. Let's see how we can create a soft landing. I mean, this is an abusive process case. That's 100% what it is. And all this, like, hiding behind civil procedure and all this stuff, like, Bill Jakes was disrespectful to me from day one. They filed a very involved lawsuit against me, who was just living in a house, like a guy living in a house, Airbnb or not. Like, I mean, Mayor Barry said what Airbnb is used for. It's like for people to make a little extra money when they're out of town. That would fit my case to a T. So I think we should all just put away the official hat and the pretense and just put on, like, the logical hat and the right and wrong hat for once.
Okay. So, Mr. Jakes, in the order I'm going to issue, I'm going to direct you to, within the next 10 days, once you get the order, by email. I have to send it to you by email this time. I want you to provide a place in Houston where your deposition can be taken. And Mr. Cohen needs to provide the address in Houston where your deposition can be taken.
But you're misunderstanding. I'm not
Now,
residing in Houston, so Houston is not where I'm at.
it can be at a law firm, or your friend's
But
law
I'm not
firm.
in
It can
Houston
be-
at all. Like I'm in South America currently. So Houston is like,
Well-
I don't know why you're picking Houston. I have no residence there. I have no house there. My parents live there. I was with them for a little bit, but now I'm not. I was actually staying with my brother, but it's a different story. Yeah, I'm not in Houston, so I don't know why Houston's even entering the conversation.
Okay, that's all I have to say. So,
It's just Houston's
Party,
wrong.
I'm
Like
gonna hang up now.
I'm not in Houston, so
okay, I'm going to hang up now.
okay.